Good afternoon, everyone. Good afternoon. I'm Carrie Abrams, Dean of Duke Law School, and it is my great privilege today to welcome you to the 2022 Raphael Lemkin Rule of Law Guardian Program, honoring our own dear faculty member, Professor James E. Coleman Jr. Professor Coleman is the John S. Bradway Professor of the Practice of Law, Director of the Center for Criminal Justice and Professional Responsibility, and Director of the Wrongful Convictions Clinic at Duke Law. A beloved member of the Duke University faculty for more than 25 years, he is a nationally recognized leader in pursuing justice for the wrongfully convicted and for protecting civil rights. Throughout his career and his time at Duke, Professor Coleman has dedicated his time and energy to ensuring that the justice system in all of its parts is true to its constitutional commitments. In the teaching he has done, the programs he has directed, the clients he has represented, and the leadership positions he has held, he has worked tirelessly to advance the cause of justice and fair treatment for all, even for the most unpopular client, even in the face of threats and personal insults. He is a paragon of integrity, the very best example of how a dedicated lawyer can serve our country and the ideals of justice and equality. And he is the ideal recipient for the Lemken Rule of Law Medal, which honors individuals who meaningfully advance and protect the rule of law in their everyday work and lives. In the next hour, we will hear much more from Professor Coleman about his career and the incredible work he has done as he talks with David F. Levi, the director of the Bolch Judicial Institute and my predecessor as Dean of Duke Law School. Dean Levi served as Dean from 2007 to 2018. He came to Duke after serving 17 years as a United States District Judge and for several years as the Chief Judge in the Eastern District of California with chambers in Sacramento. His experience as a judge has been so important to the law school, and in particular to the Bolch Judicial Institute, which has built an incredible presence and connection to the judiciary in the 5 years since it was founded by our alumnus, Carl Bolch Jr., and his wife, Susan Bass Bolch. I think most of you know that Dean Levi will be retiring from Duke at the end of this year. This is such a loss for our community and the university, although I know he will continue to do great work for the judiciary and the legal profession as he continues his work as president of the American Law Institute. Dean Levy's successor as director of the Bolch Judicial Institute, Judge Paul Grimm of the U.S. District Court for the District of Maryland, will join us at Duke Law in January, and we are looking forward to many more wonderful programs with Judge Grimm in the coming years. Before we begin, I also want to thank Peter Kahn, a 1976 graduate of Duke Law School and senior counsel at Williams & Connolly LLP in Washington, D.C. Peter's sitting in the very back because he has to leave a little bit early. Thank you, Peter, for being here today. Peter has served as a Duke University trustee, a leader and member of the law school's Board of Visitors, and as chair of the Bolch Judicial Institute's advisory board since the Institute's beginning. He has been an integral part of the Institute's growth and success over the past several years. Peter, we're so grateful for your dedication to the law school. One quick note so that you all know, this program is being live streamed and also recorded for later viewing on the law school's YouTube channel. If you didn't know we have a YouTube channel, we do. Check it out. Thank you all for being here today to honor Professor Coleman. I'll turn things over to Dean Levi now so we can get started.
Well, thank you, Dean Abrams, for that very kind introduction, so gracious. And thank you all for being here. Just looking around the room, there's so many family members here, which is wonderful. We're all here for you, Jim, and I see Kevin White, the former athletic director, and tribute to the work that you've done in the university on the athletic council, and then just so many of your colleagues and students are here. I think there's a well of affection and admiration for you that is, it's unique. And that brings us to the reason that we're here, which is the Lemken Award. Raphael Lemkin was a member of this faculty in the 1940s. He was a refugee, a Jewish refugee from Poland, and he came to Duke, and he worked here for several years. He is the scholar who actually coined the term genocide, and he was, in large part, he was responsible for the United Nations Convention on Genocide. So a very distinguished person who was pulling his life back together. And we at the Bolch Institute decided that in his honor and in honor of people like Jim, that we wanted to give a medal to people who'd done extraordinary service in the cause of justice and in promoting the rule of law, which I'm reminded is neither a rule nor necessarily law, but something actually much deeper than that, which requires a kind of character that Jim embodies. And so the recipient this year, as you've heard, is our Professor Coleman, and it is just so fitting and proper that we acknowledge his contributions over many years to the cause of justice for individual people who have been wrongfully accused, and for his insistence across the board, no matter who the defendant, no matter their station in life, their race, their religion, their gender, whoever they are, Jim has lived this principle that everyone is entitled to due process and to a more than adequate defense. And for that, we have this small token, but it stands for something really big. Congratulations, Professor.
The dean said I did not have to make a speech, so I won't make a speech. He's going to interview me about some of the things I've done in my career, but if I could have picked anything about my career that would have been special for me to be recognized, it would be being a guardian of the rule of law, holding myself responsible and holding others accountable. So thank you very much. I really appreciate this.
Thank you. So we're going to, this is sort of a, this is your life, your life in the law. And we're going to start a little bit to the west of here in Charlotte, where you grew up. You grew up in the segregated South, and you had some remarkable experiences. And your life changed very dramatically. So you worked for Julius Chambers when you were in high school, and then, lo and behold, you went to Phillips Exeter Academy, where there were all these white people. and then you went to Harvard College, where you made lifelong friends. Can you just tell us about that experience?
Well, you know, I started out in Charlotte, and I had my whole experience in education had been at segregated schools. I'd never been in a classroom with a white student or had a white teacher, but I had some really extraordinary African-American teachers. A lot of them were women. You know, we were in a school system where I don't think the school board cared whether we were educated or not, or, you know, what happened to us after public school. But the teachers in those schools cared very much about that, and you know, they saw their job as to prepare us to succeed in a world that we could only imagine, but that we believed and hoped would be different. And so I credit them with instilling in me the notion that I could succeed, that never giving up was better than never losing, and that to have confidence in myself. Working for Julius Chambers as a senior in high school, he was the first lawyer I met. I'd never met a lawyer before that. And one of my guidance counselors, a woman by the name of Marjorie Belton, who is among all of my teachers, one of the most special ones in terms of setting me off on a course that led me here. But she and some ministers in Charlotte arranged for me to work for Chambers. He was just setting up his office, and they were trying to help him get started. And so they said, well, you're going to need somebody, an office boy, to clean up your conference table. So we have this kid over at Second Ward, and they recommended me. And I met him and his secretary and the three of us, basically, and it was extraordinary. I mean, all of a sudden, I'm working for a civil rights lawyer, just starting out in his career, sort of a smallish person with eyeglasses. But it was clear that he was going to have an extraordinary impact in Charlotte. When I left that summer after my high school, his home was bombed. And what that said to me was that one lawyer can make a difference, and that the people he was opposing in court and the changes that he was trying to make, that people feared that he might succeed. And so so I set out believing that one person could make a difference and that I could make a difference.
It's good to remember the amount of violence directed at civil rights lawyers. Lawyers like Thurgood Marshall, they'd come into these towns, they'd have to sleep under the bed, literally, because the bullets would be coming in through the windows.
It was extraordinary. I mean, I had left Charlotte and I was up at Exeter, and I actually heard on the news that his office and his home had been bombed, and that was just pretty extraordinary. And those kinds of things had not happened in Charlotte regularly, at least, and then all of a sudden, that was in the news. What's interesting is that probably the thing that precipitated it was his attempt to integrate a football game that the Shriners held every year, and they picked the two best players from each high school in North Carolina and South Carolina, and they played against each other, sort of an all-star type game. And there was a kid at Myers Park High School, which was an all-white school until he integrated it. Everybody agreed was the best football player in the state, and he was not chosen. And so Chambers threatened to bring a lawsuit, and I think that's actually what precipitated his office being bombed. It's like, we don't care about schools, but football.
Football.
Yeah.
It's all about football. Yeah. Well, what about one of your college roommates is here, so I gather that your experience at Harvard was really a good one.
It was.
But you might not have predicted that.
No, and it was sort of extraordinary. When I left Charlotte, I had no idea what New Hampshire would be like. I'd never been to New Hampshire. I'd never actually, until the summer before that, I'd never heard of Exeter Academy. I didn't know anything about it. I went up there for a summer school program, and it was just extraordinary. I mean, I'd never seen education sort of done that way. And so I was really eager to have an opportunity to go back and be a student there. For me, it was an adventure, and I just, it was. I wasn't focused on the past. I wasn't, self-pitying myself, because obviously I wasn't as prepared as some of the students at Exeter. But man, I was ready to do whatever it took. And, I was lucky because, the people I met there, I didn't run into folks who suggested I shouldn't be there, or that I should leave, or that I wasn't prepared. I mean, I was just another student, and I made friends. There weren't very many black kids at Exeter, so if you're going to have friends, they were going to be white friends, and so that's what I did, and then by the time I got to Harvard, I was accustomed to that environment, and one of my roommates, as you said, is here, Dave Hughes, but he was one of my two freshman roommates, and we stayed together for the 4 years at Harvard and been friends ever since.
It's really quite a story. So after college, you went to law school. You didn't have the good sense to come back to Duke, but
I'm not sure Duke would have admitted me. So, if we're going to be perfectly honest.
Well, you might be right. But you went to Columbia. You did okay there, and and you worked at the National Employment Law Project, and I gather from other interviews that was transformative for you, or very informative for you.
Yeah.
Can you talk about that?
Yeah. So I was in law school with a bunch of students who graduated from Princeton, and they were really irritating. They wanted to talk about law and economics, and I had no interest in that. And so I had an opportunity to work at this organization called the National Employment Law Project as a legal assistant. And I took a job there the second semester of my first year, and I worked there for 2.5 years. It was a backup center, legal services funded backup center, which means that it did impact litigation in the area of employment law, so employment discrimination, labor law, whatever. There was a director and 4 young lawyers, and I worked with them. They gave me an office, and I considered myself like the 5th lawyer, and it was extraordinary. I learned how to put together cases. I learned how to, work with facts. I learned how to shape, legal arguments to present to, sometimes hostile judges, I couldn't wait to get to the office. Every day I'd go to class, and then I would take off and avoid those Princeton students and learned how to be a lawyer. It was great experience.
I mean, your passion for clinical education maybe stems from that.
Sure.
For that time.
For sure. I thought that I enjoyed some aspects of law school, reading the cases, first semester, first year interest in that. After that, more than I thought was necessary. But seeing what you could do with law, sort of law in action, the kinds of things that you might be able to accomplish as a lawyer, that really sort of lit my fuse for law school. I did well, I think, as a result of sort of understanding what law is all about, and that is why I think clinical programs are so important.
So you then clerked for Damon Keith, who I overlapped with on the bench, and he was a legend, a really distinguished person, and had a big effect on people. Can you tell us about what that year was like?
He did. So I was his law clerk when he was on the district court in Detroit, and I went out there. I wanted to clerk for a judge who who had been involved in civil rights. And so I applied to Constance Motley and Robert Carter and Damon Keith. And Keith asked me to come out for an interview, and I'd never been to Detroit. So I went out, and, he sent me in his, big conference room, and I was totally unprepared. He made the offer to me before I could talk to the other two judges. And I panicked and I accepted.
You did the right thing.
Yeah, well, except that when I got home back to New York and announced to my then wife and my daughter that guess what? We're going to go to Detroit next year. And they said, well, you may go to Detroit next year, but I don't think so. So I ended up, and then I got a call from Judge Motley, who heard that I had accepted the offer. And Lonnie Guinier, who was at Yale, also accepted the offer to clerk the year I clerked. And Judge Motley was not happy. She called me on the phone, and I was at home, and I had the phone, and she said, hello, this is Constance Motley. Why aren't you going to interview with me? Judge, I don't know. But yeah, that was an extraordinary experience, though. Judge Keith, sort of, I guess you would call it a form of affirmative action. He made a real big effort to hire black law clerks. And so, I had an opportunity to work for the judge. Lonnie was my co-clerk, and, we were a staff of 5, and we were all African Americans. We felt a special obligation to get the work that we were doing right, to protect the judge and basically to demonstrate, that his decision to hire us was a valid decision for a federal judge, and it was great. He told us, we've got to do good work, and you got to take into consideration, what is fair in every case. Is it fair? Was it fair? What happened to the plaintiff? Was it fair? And if it was fair, does the law provide a remedy? So that was kind of the approach we took in all kinds of cases. I drafted a lot of antitrust opinions and stuff that I didn't have a particular interest in at the time, but that it was quite a year.
What's interesting to me is some people who clerk, they love that year, and it makes them want to be a judge someday. But that didn't happen with you. Now there can be other reasons why that's true. Although I think you would have been a tremendous judge, but you've always wanted to be the advocate,
lawyer, right?
A lawyer, yeah.
I saw the judge, and he was an extraordinary judge, but I thought he was somewhat isolated. Basically the people he could discuss his work with were the law clerks and his secretary and and the bailiffs. So I didn't see that for myself. And plus, I didn't particularly think that being neutral was kind of
what you wanted.
Yeah, I wanted to be an advocate.
Yeah. So you left the clerkship, a good year, with an extraordinary co-clerk too.
Yeah.
Two of you together, that's like the dream team or something.
Yeah,
that's pretty good. And then you went to big firms in D.C., K. Scholler, and then Wilmer.
K. Scholler in New
York, and then to Wilmer.
Yeah.
And you had a long career at Wilmer. So private practice, and then you took some breaks in there. You worked at LSC, Legal Services Corporation. You worked at for the House of Representatives and
Department of
in
Education.
the Department of Education. You were Deputy Counsel, General Counsel, and you had an active pro bono practice. I'm just, I'm sure a lot of the students in the room. How did you put together this mix?
Well, when I looked around at what people were doing, what lawyers were doing, I decided that I wanted to be a Washington lawyer because I thought that Washington lawyers, I thought that was the kind of career I wanted. They were interested in the public interest. They represented, big, important clients. They got involved in big cases. They cared about the profession. They were involved in, in governance of organizations, public interest organizations. And so that's the kind of career I wanted. At Wilmer, John Pickering was senior partner, but also my mentor. I did a lot of work with him. Lloyd Cutler, who was kind of the inside guy. He was the person who would go into government. And, they set up a firm where that was part of what it meant to be a lawyer. That it wasn't that pro bono was something that you did on the side. That's what we did as lawyers. And our senior partners got involved in the cases. They were counsel in the cases. And so, my best friend at the firm, John Payton, and I were associates, and we decided we wanted to be like Lloyd Cutler and John Pickering because they seemed to be having a lot of fun, and they were doing good work. We got to know a lot of public interest lawyers, and they would call on us to get involved in cases. And so, it took a lot of time, and I'm not sure. I tried to spend as much time with my daughter as I could, but honestly, the practice of law was taking all of my time, and that's kind of the way it was, because I was doing the PN work and the pro bono work. I wasn't doing just pro bono work and not PN work. So, but I loved all of it.
Do you think it's still possible today to put that together, to be a lawyer in private practice and also have a significant pro bono practice as well, or public interest practice?
I think it would be much more difficult, but I think it depends on the law firm. If the law firm's goal is to increase the profit for partners, then it's much less likely that you could do what I did and what other associates also did. But if you find a firm that was like Wilmer Cutler in the 70s when I joined it, and senior partners who make that part of what they think the obligation of a lawyer is, I think you can do it. But I'm not sure how many of those firms there are out there right now.
So at some point during that period, you became nationally known because you were part of the Ted Bundy legal team, and you were a prominent member of that legal team. And most of the people in the room probably, because of documentaries, know something about Ted Bundy. I actually know very little about him, but what I do know is that he killed a bunch of people in the 1970s. They were all women, and it wasn't pretty.
Okay.
Yeah. Is that you were his lawyer.
That's pretty.
I think he confessed to 30 murders, and the Wikipedia suggests that there were probably a good deal more. I shouldn't really laugh about it because it's. But you represented him during the death row.
Correct.
When he was on death row, and that was death penalty litigation, and you were quoted as saying, because you got a lot of grief for representing this guy. I think people,
including within my firm, there are some people who thought we shouldn't be representing a person like that, but that was where having John Pickering and Lloyd Cutler as our senior partners, their view was that this is somebody who needs a lawyer, and he needs a really good lawyer, and so, that's what we do.
So you were challenged in the Orlando Sentinel, because he was on death row in Florida. Quotes he was saying, "If you don't have good lawyers defending these people, the system will be out of control."
Right.
So why don't you talk about that?
Well, because what I felt was that the notion that people should be presumed innocent until they're found guilty by a jury, I think is an important concept in criminal law. I think the only way you can protect people who are innocent from wrongful convictions is by treating every defendant as if he or she were innocent. And then that way, if you take the care that ought to require to make sure that you're not convicting an innocent person, then I think you will convict fewer innocent people. So, with Ted Bundy, people wanted to take shortcuts because they assumed that he was guilty. I mean, the statistics that you described, the number of people he had killed, the number of people suspected he had killed, everybody was ready to just assume that he was guilty of the 3 crimes in Florida, and therefore he should be executed. But there were serious legal issues, and I thought that allowing him to be executed without forcing the state and the courts to confront those issues would have been a disservice to the system. It would have undermined the system. So that's what I tried to do.
So how do you think through the issue that I think everybody in the room has to some degree, which is you want to put your energies into something you really believe in, and so you might choose to do so. You might choose to be a public defender, or you might choose to be a prosecutor, and you'd say, "I'm very comfortable advocating on behalf of those folks." But when you're confronted with somebody that you consider to be evil or just despicable,
Or the world,
or the world, people say, like, how could you even be in the same room with a person like that? And we can all think of people that we would really hesitate. How do you muster the courage and maybe the sort of professional allegiance that you have to overcome that aversion?
Well, because I thought that I had an obligation as a lawyer. I mean, I could have chosen not to represent him, but I thought that his case was important, and I thought that it was an important, opportunity to make that point. That notwithstanding what the public thought about him, that he deserved a good defense, and that the system should have been fair to him. And I thought that my law firm was, had stature that would, if we showed up in court representing him, we might make that possible. So it didn't bother me. I never hesitated personally or questioned whether I should do the case. I felt very comfortable doing the case.
I mean, there's a long tradition in this country of lawyers representing people that are reviled. John Adams represented the soldiers in the Boston Massacre, and all the way through the present. But do you think that sense of obligation may have diminished?
I think so. I think what's happening now is that I think the public and some lawyers even feel this way, sort of, start to treat lawyers as their clients and try and sort of start to treat the client's issues and the client's goals as the lawyer's personal goals and issues. And as a result, some lawyers, and some lawyers practice that way. It's they're not just advocates, but it's this is a political position for them. And the client is just kind of incidental almost to what they're doing. And I think that's really unfortunate, because I think that as lawyers, the greatest impact that we can have is sort of the traditional, to take the traditional approach, which is that our client's cause is not our cause. We have an obligation to the client to act in the client's interest, but we are not our client, and that there's a separation between the lawyer and the client. And I do worry a little bit that we're moving away from that notion.
So in the 1990s, early 90s, you started teaching here at Duke. Yeah. And you became a professor of the practice in 96. So what was it that caused you to want to move away from the life you had, which sounds very interesting, and come back to North Carolina?
Yeah. Well, first of all, I'm a professor of the practice. There's a story behind that, right? So when I came here originally in 1991, I was a professor of law, and I was going to be a law professor who wrote articles, and
some of them are in the room.
I know, and some of them I love, and they're my good friends. But that turned out not to be for me. I didn't have the discipline. These are very disciplined people, and I didn't have the discipline to read cases and books focused on some narrow issue that I was going to write about. And so I went back to my law firm. I said, I can't do this. I love teaching, but I couldn't do this. I went back to my law firm, and then I immediately regretted I had left. So Kate Bartlett, actually, I guess Pam Gann was the dean when I returned. And then Kate Bartlett became dean and said, well, what you ought to think about is this thing, professor of the practice, that Duke has. We didn't have one at the law school, but she described it as you would be a teacher, and then you would be expected to continue to be involved in the profession. And I thought, well, that was made for me. Yeah. Right, that could work. And so, and I always wanted to be a teacher, though. I mean, when I left college, I was going to teach this little private school in Cambridge, and it was a school where I had been I had worked there as a tutor, and I was going to work full time. In fact, I did for a year, and then because of the draft, I was sort of one of those people that, because of military service, I ended up joining the Navy JAG program and going to law school. But I always wanted to be a teacher. So when I left Kay Scholler and came to D.C. with the Legal Services Corporation, I agreed to do that for 2 years, and then I was going to go back to Kay Scholler. But while I was at the Legal Services Corporation, I started to think about teaching, and I interviewed at NYU, and I had an offer to go there and teach. But I thought that I would be a more effective teacher if I had actually practiced law a little bit. So I turned that down and then decided to stay in D.C. But I always wanted to be a teacher. I mean, even at my law firm, I think some of the associates would probably say that when I became a partner, I was sort of a teaching partner. I would bring them onto my cases. I would give them a lot of responsibility. And train them to be good Washington lawyers.
Well, I can personally attest that you are a very accomplished teacher, because the two of us taught together.
Yeah, we did.
Actually, I think you
2 years.
You were teaching me how to teach when I got here.
No, that wasn't.
We enjoyed that a great deal, and you've been such a force here within the law school, but not just only the law school. You've also been a big force on the university campus, and you chaired the Duke Athletic Council, and I understand that athletics is reasonably important to this university. So, there is a lot of issues there. And then in 2006, you chaired the university's ad hoc committee to review the lacrosse team, essentially, what was happening to the lacrosse team. And probably, again, most of the students here probably don't know about this all that well, unless you've looked at the ESPN documentary. But you know, there was a very tumultuous accusation as a result of an accusation by an African-American woman that she had been raped at a party that the lacrosse team had staged at a house that was right behind the house that I subsequently lived in. And it was known as the lacrosse house. And there was sort of a common view that the lacrosse team had done this thing, and you were a voice that said, let's wait for due process here. Can you talk about that experience? Because it was a very hard thing on this campus.
It was really extraordinary. You know, I woke up one Saturday morning and there was a newspaper article that there was an allegation that the lacrosse team had raped a woman, a dancer, exotic dancer, at a party during spring break. And it quoted the prosecutor making statements about the guilt of the students. And I thought that, you know, that's an unfair thing for a prosecutor to do, and it's the kind of thing that leads to a miscarriage of justice. So I sent Dick Broadhead an email saying that, you know, if there's anything I can do to help, just let me know. And Paul Hagan on our faculty was chair of the academic council, and they were sort of in crisis mode. And I think Paul recommended to Dick that they appoint a committee to look, because there were allegations in the press that these students were, you know, just raising hell everywhere, and the community adjacent to East Campus, you know, people were complaining, being quoted in the paper about the conduct of the, and so some people suggested that this had been going on in the university and that the university hadn't done anything about it. So Paul suggested that the president appoint a committee, and because of, you know, I had experience doing internal investigations at Wilmer, he asked me if I would chair the committee, and I agreed to do it. And I had worked with some of the people in the athletic department. We had revised the drug testing protocol, and Dorian and I had done that in private practice for the USA Track and Field Federation, so I knew a little bit about that. And I got to know some of the athletic department folks, and so I think they believed that I would be fair, and I told them I would be fair, and you know, I met with my committee. I put together notebooks for them, you know, news articles about what allegedly had happened, and I said to the committee, the way we're going to approach this is we're going to interview everybody who's quoted in the newspaper about these students, about what they've done. We're going to look at the police reports that come out of the committee to see how many of it involves Duke lacrosse students. And I said, we're going to be fair and we're going to call it, you know, straight. We're not going to fudge anything or hedge anything. You know, at one point, the parents of the lacrosse players were really kind of stressing out because they didn't know what was going on, and they thought, you know, their sons were going to be, you know, prosecuted for rape. So I arranged for my committee to meet with a sort of a representative group of the parents not that they had anything that would help our investigation, but I wanted them to know that we were going to do a fair investigation, and that in fact we cared about what was happening. So that's what I did.
The newspaper and media interest in this case was just gigantic because elite athletes, white students,
Duke,
African American accuser, Duke. It had all this whole mix of things. It's a little hard to understand exactly what made it so explosive, but those were certainly some of the elements, and it just blew up everywhere. Eventually, it turned out that the DA had withheld evidence and manipulated evidence. The charges were unfounded, and the students were, the indictments were dismissed, or the information
dismissed.
Dismissed. The DA ultimately was disbarred, and I think maybe went to
spent a day in jail.
Spent a day in jail, and I'm just dealing with that much criticism and outrage that I'm sure you had to deal with. Can you talk about that for a little bit? Because that's not, in retrospect, it might seem like nothing, but at the time, for you and your family, it was probably very difficult.
Well, I mean, I was being attacked by people who thought I was a traitor, that, these white kids raped this black woman, and here I am defending them. And then I was being attacked by some of our alumni who had no idea what I was doing, but they were saying that, why aren't you out there defending these students? And well, that's kind of what I'm doing. So on both sides, but again, I had gone through the representation of Ted Bundy, and particularly at the very end, when it became kind of clear that he would be executed, the sort of attention was pretty intense, and I just tried to put it out of my mind and not focus on that, and just stay focused on what it was we were trying to do. And that's kind of how I approach the work that I do, is to just stay focused and not get distracted and sidetracked, because it's easy to do, to get caught up in. I was being asked to appear on cable news every night, and my approach when I was representing Ted Bundy was that I generally didn't talk to reporters about the case unless I felt I could educate them. So if I felt that I could educate a reporter who covered the case and who was going to be a repeat, who was going to be there, or that I could explain something that, if the reporter reported it accurately, might educate the public about what was going on. So I would get involved. Otherwise, I just stayed away from that stuff. And that's the approach that I took with the lacrosse case. And when we issued our report, we had a press conference, and I said, here's the report. And the reporters, particularly the television reporters, they wanted to know, well, what does it say? And I said, read it. They said, well, you summarized it. I said, no, read it. The whole point of writing the report is so you guys could read it. I said, I've got all the exhibits, everything. Just read the report.
Interesting. So the lacrosse players, Ted Bundy, all rather, this is somewhat unique situations, but maybe the underlying elements of what you were trying to do there, carry forward into your work on wrongful convictions. Yes. So you and Teresa Newman and Jamie Lau, you've created this clinic at Duke, and it's had some wonderful success. Could you talk about that? And those clients are not, they don't have parents who are advocating for them, and they're not Duke students by and large.
Right. Well, in some cases they have parents who are supporting them, and who are basically contacting us and asking us to help. But you're right, they're not influential. What we did, Teresa and I, and then later Jamie joined us, we decided that the approach we were going to take was not going to be an adversarial one initially. What we wanted to do was to do our investigation. We would write up a report, we would give it to the prosecutor, and we would ask the prosecutor to help us show that our client was innocent. And we offered to, open up our files and, you can see what we're doing and hope that they would read it and join us. In the beginning, that it worked out that way in the first couple of cases, but then the prosecutors decided that they would take a different approach and that they would not even consider it. We continue to do it, but they, basically it's sort of more for our purpose than theirs. And so then we became a litigation firm. They misjudged because, we were fine being litigators. I didn't mind that. I think we've turned ourselves into, one of the top litigating firms, clinics in North Carolina. And again, what we're trying to do is what the system ought to do itself, which is that we're trying to identify a miscarriage of justice and get the system to correct it.
Is there one or two of those cases that really stands out for you?
Well, one case that, they're all different, but one case that I think was important for the clinic was Lamont Armstrong. You know Lamont, you knew him.
Wonderful guy.
Yeah, just extraordinary. He was convicted and sentenced to life without the possibility of parole in the death of a woman who was a professor at North Carolina A&T University. And he was innocent, and we had a number of students work on his case, and we did our thing. We filed an MAR, motion for appropriate relief, which it sort of summarizes what we thought the facts were, and then the legal basis on which we should get relief. And something pretty extraordinary happened. The Greensboro police assigned a cold case officer to look at the case. He went back and looked at the evidence, and they found a palm print that they thought had been left by the perpetrator, and he ran it through a new database that they had, and they got a hit. And they identified the person who actually had killed the victim, and they then conceded that Lamont was innocent, and we went to court. And the judge, when he was ready to free Lamont, he said to him that we judges put our pants on the same way, I guess, dresses too, same way everybody else does, and we come into court and we want to do justice, but we don't always know if we've done it. He said, but this is one case where I believe that we have done justice. And he came down and he shook Lamont's hand. And that night at dinner, I told the students that they had witnessed a To Kill a Mockingbird moment. It was a real life situation where we had done something really important.
Lamont?
Atticus Finch.
Lamont went on to, you're Atticus. Lamont went on to be a big supporter of the clinic. And,
He did. And Sorry.
He seemed to be utterly without bitterness too, which I thought
Pretty extraordinary. Yeah, pretty extraordinary.
Well, what's next? You've done so much. You can continue doing it.
Yeah, that's next. I mean, it's like, I don't know why I would stop. I enjoy it. Well, you'll know this. I mean, some people won't. But there was a senator, Hubert Humphrey, from wherever he's from, Minnesota. And he was really big on civil rights back in 1948, and he was called the Happy Warrior. And I sort of think of myself that way sometimes. It's like I really, I would love to resolve all of our cases, with prosecutors who look at the evidence and agree that we're right. But on the other hand, if they don't want to do that,
that's okay too.
I'm perfectly happy to litigate against them. I wake up every morning happy to be able to do that.
That's amazing. We've got about 1 minute left, and I have two questions I want to ask you. One is just about the role of race in your life and your work.
Yeah.
And the other is about your mentors.
Yeah. Well, I mean, in terms of race, I grew up, and as you said at the very beginning, in a segregated time. I had no, except incidentally, I had no contact with white folks. My father was paid to be a truck driver at a dry cleaners, but what his real job was to take care of the equipment, repair the equipment, but he couldn't do that work because he was black. And when I left Charlotte, as I said, my teachers had me believing that the future could be different and that I could make a difference. So when I left, I didn't leave looking backwards or with bitterness. And I think that was important. You can get bitter and get sidetracked. And if you want to make change, I think you can't do that through bitterness.
What about your mentors? You've mentioned several of them, Judge Keith.
Judge Keith. I mean, it's been an extraordinary group of lawyers. Beginning with Julius Chambers, Judge Keith, Fred Livingston at Case Scholler. And what's been interesting is that all of them have thought that as lawyers, we have an obligation to the public interest. And that's how they practice law. And so they were, that was the kind of example for me. And, and I hope that, in my own career that I've been an example for my students in the same way.
Well, what a privilege for all of us, particularly for me, to be here with you today. You're really an inspiration. You often say that something is extraordinary. Let me just say, you are extraordinary. Thank you and congratulations.